Hello and welcome back. This is Roger Royce with the 10,000 Startups podcast, legal strategies for startup success. For every week, we talk to a specialist in some area of startup law or tax in this case that's relevant to you as a founder or an investor in a startup. And today we're going to talk tax. We've got Robert Houston, who's of counsel with BPM LLP in San Jose, California. I've known Robert for many years. And being here in the heart of Silicon Valley, of course, he deals a lot with startups and a lot with the tax issues that arise in connection with startups. So if you're ready, let's talk a little tax, Robert.
Okay, let's do it.
Okay, first of all, let's talk about the very first issue that always comes up with any of these companies, and that's choice of entity. And pretty much everybody thinks they're going to be a Delaware C corporation, and that's the end of the discussion. Seems to me it ought to take a little more thought to go into that decision. How do you approach this?
Well, absolutely, Roger. I mean, obviously, our quick kind of review, you could be a sole proprietorship, right? You're going to put it on your personal tax return. You could form an LLC if you're a single owner. That's a disregarded entity. It'll go on your Schedule C. Or you might have a partner. And so you may have a tax partnership is one opportunity. The other is a form of corporation. And that corporation has two avenues. One is to be a C Corp, which is the default type of corporation, or you could elect to be in what's called an S corporation. S corporations are a lot like partnerships, except you're a corporate form. So it has pass-through earnings and losses out to the shareholders. So you really need to take a look at, what are your exit goals? I think the first thing is what is your plan for this business? Are you trying to build an enterprise that you're going to try to sell it, go public? Merge? I mean, what is your goals here? So that's really kind of the first question I would be asking is, and how are you going to fund it? Are you bootstrapping it? Is this with your, friends and family money? How much money do you have to fund your enterprise? When are you going to run out of money? Because if you're starting from scratch and you have an idea, maybe we're talking tech here, and you're going to build some sort of, artificial intelligence company, or you're going to build some sort of SaaS software model company, that takes money to have engineers to build your product out, and that can take time. So I think you have to look. When are you going to run out of money, and where's your source of funding? Is it from venture capital? Where are you going to get additional add-on layers of money coming in? Because that might dictate the type of entity you choose.
Okay.
And so that's the first thing I'd be asking. And then the second thing we might be running,
because VCs, they only want a C corporation.
They want a C Corp, absolutely. And so if you're looking at that's your source of funding, then there's no reason to choose any other entity that formed than a C corporation. But if you maybe you're a serial entrepreneur and you were successful in your last company and you got plenty of money in the bank, and now you're going to go and start a new company, still might choose C Corp. And the reason might be is what's called our Internal Revenue Code Section 1202, qualified small business stock. If you hold that stock, original issue from the company, there's a lot of rules to qualify, but if you're the startup founders, and you have less than 50 million in assets the day before and after that you issue these shares, and you hold them for 5 years, and you have a transaction where you've sold the company, you can exclude up to $10 million of gain, or 10 times your basis. So
let's pause on that for a second to make sure people get the point. So stock issued by a C corporation,
yes,
that qualifies.
Only a C corporation, yes.
Only a C corporation may qualify. So an LLC that elects to be taxed as a partnership, that won't work. How about an S corporation?
That's right. Or foreign. You have to be domestic C corporation.
Domestic C.
You can't go form a C corp in Canada, then issue shares. That won't qualify in the U.S. No. Yeah. So that's a consideration. We can get you to a C Corp later if you start out as an LLC or an S Corp, but there's some more restructuring and some complexity there. And your 5-year holding period doesn't start until you're a C Corporation.
Yeah, so to pause on it, so if you, even if you're a founder, if you have stock in a C issued by a C Corp for cash or property, I guess, not other stock, right?
Right.
And if it's a qualified business, which is a pretty easy hurdle,
Right. As long as you're not in banking or finance or service, like attorneys, CPAs, we don't
Yeah,
qualify.
of course,
Yeah.
always beating up on us lawyers and accountants. And if you hold that stock for 5 years and on exit, you're not going to pay a dime of federal income tax on a gain up to, I think you said $10 million.
10
or
million,
10
that's
times
right. Or 10
basis.
times your basis.
The greater of, right?
The greater, yeah.
Yeah, that's a huge benefit. That's a good
Huge
reason
benefit.
to form a C
And
corporation.
this law came in place in 1993. But we're talking about startups. So like tomorrow we're going to start a new business enterprise. And
Right.
if this is a hot area and you think there's an exit in 5 years, you might just choose C corp right from the beginning.
Right. Now, why would you not? Why would you ever use an
Well,
LLC?
maybe you have a whole bunch of other sources of income and you want some pass-through treatment of the losses in the first years. That's been diminished somewhat right now because your research and development expenses you're going to incur under the current tax law, section 174, you got to capitalize them and amortize them over 5 years. That's in play now for a couple more years until the end of 2025, and then the law goes away. But right now, starting 2022, you have to capitalize all those research and experimentation expenditures and amortize them over 5 years. So you may not have as large of amount of loss pass through if you're in a pass through structure like a partnership or S corp.
Gotcha. So let's talk a little bit about formation. Everybody just assumes that there's this magical thing called founder stock that is not taxable. Because normally when you exchange property for property, that's a taxable exchange. So if I have, my crypto asset that I paid nothing for and it's worth $1,000 and I exchange it for some other property that's worth $1,000, I don't get cash, but I still have taxable income.
Right.
And somehow when you get founder stock in a company, you don't pay any tax. So why is that? What is this magical thing called founder
Yeah,
stock?
we have a tax-free provision under Internal Revenue Code section 351 that allows you to say you've been working on your own on this, right? Or you have some computers, you've got some software you already developed, maybe you have a patent you developed. You can contribute those assets into a corporation and receive stock back, and that's a tax-free exchange under 351. Now, if you have any debt, the debt can't exceed the assets. And so you have to be careful that you don't run afoul of those rules. And, let's say you've been operating as a tax partnership. Well, you could, contribute all the assets out of the tax partnership into the C corporation exchange for C corp stock. As long as you're not going to violate the debt rule, having too much debt over the assets, you can now end up a C corp stock in exchange for all the assets in the partnership. You distribute those shares out to the partners, the partnership dissolves. So there's a lot of ways of getting assets into a corporate form.
Okay, so what are the requirements of 351? So I want to make sure I don't mess this up. I get stock, but I think you said it's for assets. How about if
You
it's
can only get stock. You can't get a promissory note. You can't get preferred stock. It all has to be common stock in the company.
What about if I provide services to the company?
If you provide services, rent's a different. It's services. This is what we call compensatory shares. And so if you're going to get stock in a company for providing services, now you're under a different code section, in section 83. And so if, for example, Roger's starting a company and he's going to provide services, he's going to get 10 shares of stock. If he receives those shares and there's no restrictions on them, there's no vesting on them, they grant him the shares, he provides services. And maybe it was legal services. Maybe the company says, hey, Roger, we don't want to, we're kind of tight on cash. How about you taking shares for your legal service? He can say, sure, I'll do that. Right? He's going to take a bet that maybe his company becomes successful, and he's not prohibited from doing that. So he gets the shares for his services. He received properties. That's a taxable exchange.
Yeah.
In that context. So if you're going to be an employee of the company and you're going to get less salary and get shares, that's compensatory. So it's taxable fair value in your W-2. If the company puts a restriction on it, says, we're going to grant you these shares, but they vest over 4 years. Well, you have a choice. You can have an income event based on fair value when you get the shares over the 4 years, or you can do what's called a Section 83B election, and you can elect to include the fair value of the shares in your income on day
Let me come
one.
back to that before we
Yeah.
move to 351s, because that's a whole topic by itself.
Yeah.
So I think the other requirement is that the transferors as a group have to have control, meaning 80% of the company.
Oh, yeah. Back to 51. The transfers have to have control before and after, which is defined as 80%.
80%. And
Yep.
so the scenario we often see is that founders form a company, they transfer their IP in cash, they get their tax-free stock, and they operate for a year or two, and then they want to bring another founder on. Who says, well, I don't have, the stock's worth so much money, I can't buy it, but I can contribute my IP because I've got this whiz bang know-how or whatever.
Yeah.
And they contribute it to the company, or a patent, maybe. I've seen that
Right.
many times. And then
Yep.
they get stock, and they're expecting that to be a tax-free transaction. Any
Yeah.
problems with that?
Well, it might be taxable because of the fact they don't have control before, and they wouldn't have control after unless they're going to end up at 80%.
Right, because it's a different transfer
Different.
group.
Yeah.
Yeah, so that's where people say, well, it's founder stock, it should be free. Well, not necessarily, right?
That's right.
Got to jump through those hoops.
You might be looking at a different merger type structure to combine two companies into one new company. So there's some other ways of maybe getting there, or creating a tax partnership below. So there's different ways of maybe structuring to bring that person on. But yeah, that might be a taxable event.
Yeah, we've seen that where we say, well, here's an idea. Why don't you drop your patent into new corporation and merge new corporation with startup? And that's a tricky thing to do. I'm not going to say I don't know if you have an opinion. I'm not going to say you can't do it. I'm just going to say it's a tricky thing to do.
It's a tricky thing because the rules say you have to have control immediately before and after. And how long is after?
Yeah. Right.
That's the big issue.
Yeah, and if you do a 351, your patent goes into corporation for stock, and then you immediately transfer that corporation. Well, then you don't have control of that company after.
That's right.
Now you got something less than 80%.
That's right.
So, and then I know there's a ruling in some cases out there where the question is how long is long enough to wait.
Right. Right.
But that's where we need someone like you to come in and say, I'm willing to sign that return.
Yeah, and you're going to have to do some research. It's again, as Roger alluded to, there's a lot of court cases and rulings that we would look to see if we have enough authority to get to a signing position.
Right.
Or how are you going to structure it? Yeah.
Right. So let's go back to what you're about to talk about vesting, because of course, every company I form, every startup, we're going to put vesting restrictions on the founders. And just for those of you in the audience who might not have run into this, vesting in effect means that the founder is going to earn into their shares, or not just a founder, any service provider, meaning that if they leave the company's employ or stop being a service provider, they're going to have to sell back or give back or forfeit a portion of their stock.
Right.
And for corporate purposes, we always issue the stock now, and then we have this right to repurchase at some super low nominal zero price, close to zero price.
Yep.
So as a tax matter, how is that treated?
Well, again, if in fact, there's a couple different scenarios this can come and play. Let's say we've already set up the corporation. We have, say, 3 executives. They issued the stock, and then they get a year and a half out, 2 years out, and they need to raise money, and the venture capitals come in, and they want to make sure those founders are going to be staying and are not leaving. So they'll now subject those shares that they already have that are fully theirs. There's no restrictions on them, and the VCs will subject them to vesting again. And so all of a sudden now the shares you thought you could do anything you wanted with now have a 3 or 4 year vesting period on it. And just like Roger said, subject to terms and conditions of forfeiture, repurchase at a agreed upon price. Not a lot you can do there. If you want the money, you're going to comply with the terms, and so that's something to be aware of. That could come up.
And just not to be too technical, but let's suppose that someone forgets to make that 83B election within 30 days.
Well, it's interesting on that. If you already have the stock and they're subject to the revesting, The 83B election is kind of, because it's not a taxable event, right? So you can do the 83B election, but it doesn't accelerate it. You have no income to report, is my point. So if I already have the shares, VCs come in, a round, and they subject us to vesting over 3 years, we will do an 83B election, but we don't have an income inclusion at fair value of the stock.
Because there's no transfer.
There's no transfer. That's right.
Let's suppose that we have the shares subject to vesting from day one.
Yep.
And we forget to make that 83B election. I see that all the time.
Yeah.
What's going to happen?
I can't, on top of my head, I know that you got to do it within 30 days.
Yeah, you got to do it within 30 days. It's hard and fast. And if you don't,
hard and
you're going
fast,
to have an income inclusion on every vesting date.
That's right.
Because that'll be the date that the transfer is deemed to occur.
Correct.
On that, when you see service providers come in, I mean, it's fun to talk about this, but usually they're not going to get stock, right? They're going to get options, aren't they?
Yeah, and options, there's different types of options, obviously, that are being granted. Your typical non-qualified stock option gets granted and has a vesting, and or it could be a statutory option which has special treatment. The main thing you really need to focus on, they need to be issued at fair value, based on Code Section 409 Cap A, which came into the law back in 2004, I believe, and got extended out to 2005. And there was a lot of controversy about this. Well, we're now been living with it since then. So everybody's pretty accustomed to what the rules are. And one, you have to get a valuation from an independent third party to be safe from penalties. Now, the board could decide what the fair value is and issue stock based on that, but you don't have any penalty protection if the IRS comes in. If you get a third-party valuation, you at least have protection against penalties if you didn't issue at fair value. And so you have to have the 409A, and you typically are going to only want to issue options once a year when you have a valuation in play, because
they're good for a year.
Right? Yeah, every year, and you should annualize your option pool and grants based on that valuation.
And it's not so much the IRS I'm worried about. I'm worried about the acquirer. And when the acquirer brings their accountants into due diligence, if they don't see that valuation report, they might make you cancel all those options, right?
That's right. That's
the bigger problem.
So that's another bigger issue. So again, if you're going to be a C Corp, you're going to be granting options to your employees. You want to make sure you're doing 409A valuations from a third party valuation firm.
Let's stop on there. We just said that if I get stock for services, I got to pay tax. What if I get options for services? Then what?
Well, typically options are for services in some form, either as an employee or independent contractor, right? A lot of vendors who provide services to the C Corps will get options as part of their services, or all. Same rules apply. You could do an 83B, but you're not going to be doing that because there's no liquidity here. These are options. You can't sell them. And once you make an 83B election, let me back up. If you get options, you don't have property under Section 83.
Right. So I have no taxable event on receipt of the
taxable event on grant. You cannot do an 83B election because you did not receive property.
Right.
If you receive stock, that's property. And
so if I exercise the option,
once you exercise, then it's fair value date of exercise minus your strike price is your gain.
Yeah.
That's ordinary income, subject to W-2 reporting if it's a non-qualified stock option. If it's an incentive stock option, then you exercise, you will be subject to alternative minimum tax personally on your personal return. And then you have to hold it a year and a day before you could sell it, and then get capital gains treatment.
Gotcha.
And if you have what's called a disqualified disposition, you sell it before the year, then it reverts back and it's subject to withholding and W-2 reporting.
Okay, well, thanks. Let's shift gears a little bit. So now we formed our company, we've got our founder stock, we got our option plan in place, we got the team, we got the tech. Now we just need the money.
Yeah.
So the investor comes along, and I'm going to try and get them to buy a safe, or a convertible note, something like that. First money in, because it's not enough to justify preferred stock. Does the company have any bad tax consequence when it sells a safe or a note?
Well, you have to look to the safe notes and the terms and conditions, because from a debt perspective, everybody's saying this is a loan, but almost always the standardized safe notes, the new ones, you go all the way back to terms and conditions, there's always a clause that says this will be treated as if you were issued common stock. And so from a tax perspective, you receive stock.
So you'll take that position, that
Yes.
stock for purposes of starting the holding period running for
Yes.
capital gain.
Correct.
And will you actually report it that way on the financials?
Well, the financials might be different than the tax return.
I see. Okay.
Yeah.
That explains a lot.
Yeah,
Actually.
GAAP's going to look at the note, the whole terms and conditions of it, and they're going to decide based on the facts. Is it truly a debt instrument or is it equity?
Gotcha. All right. Well, I can't leave this discussion without talking about kind of a big issue. In Silicon Valley, where we are, a lot of startups come here from other countries.
Yeah.
Or people want to go to other countries almost immediately. The markets are truly worldwide and global. If we have international founders or international markets, does that raise any special issues for tax purposes?
It can. Yeah. I mean, it's a huge area of concern. We see a lot of companies who are successful, say in Australia or New Zealand or England or wherever, and they want to come and access the U.S. markets, go public. So we'll see a lot of companies that are corporations, say in Australia, they have customers, but they want to reform into the U.S. We used to call those flip ups. I'm not sure what they're calling them today, but there's a lot of terms. But essentially, they're going to form a U.S. holding company, and they're going to exchange their stock for their Australian shares for stock in the U.S. company. That should qualify as a tax-free exchange. And now they have a U.S. parent, and then they eventually could go public in U.S. markets. They could go get money from VCs. I've seen startups where they wanted to raise U.S. venture capital. The venture capital said, "That's great, but you got to have a U.S. entity.
Right.
We're not gonna invest directly in Australia, but we'll invest in a U.S. parent company."
How about if we're going the other way? What if I have a bunch of founders that say, "Hey, I hear if I form a Cayman Islands company, I don't have to pay any U.S. tax." Does that work?
Well, yeah, but you start getting into special rules about moving assets out of the U.S., especially intellectual property. There can be a tax charge based on the fair value of that. And so there's a lot of complications. In fact, we had a case the other month where 3 U.S. founders, U.S. taxpayers, were going to form a new corporation. They're going to do some software of some kind, and they found an investor in a foreign country. The investors said, "I'm going to put in, say, 20 to get 20% of your company, but I won't invest into the U.S. because I don't have a treaty for my country, so I want to go into Canada." So these 3 U.S. guys with great intentions and IP, they have kind of all worked on, outside of an entity, and they're going to contribute it in exchange for stock. So they formed a Canadian company up in British Columbia, C Corporation, equivalent to what our U.S. laws are. And they contributed all the intellectual property, know-how, all their know-how on how to do this in exchange for stock. And then the foreign investor put in the 20 to get 20%. So they exchanged property under the rules. Know-how is one of those items listed under the tax code, and they moved that offshore out of the U.S. That's a taxable event. Immediate recognition of the fair value of what they gave up. Well, in this model, they got 80, and take 80, maybe it's 80 million, maybe it's 80,000. Whatever the number, they have a taxable event that they need to include in their personal tax returns, because they moved the IP offshore.
Ouch. Well,
very, very bad transaction. They didn't seek U.S. counsel. They were always looking at what do we do in Canada.
yeah.
And we were involved on a different question, and we weren't able to help with the question because the underlying facts was such a problem.
Yeah.
So be careful if you're talking about going offshore.
Be careful.
Because the U.S. is constantly trying to shut that down. You've read in the paper, Wall Street and everywhere else, all these big giant tech companies, all their entities all over the world, and we've been passing tax laws to try to shut that down. And so if you try to move money property offshore, you could have an immediate tax hit.
Okay, well, good to know. Well, Robert, we could talk all day about
Yeah.
tax, but we've hit some of the high points in startup tax. I want to thank you for being here. This is Roger Royce with the 10,000 Startups podcast. We're talking to Robert Houston from BPM LLP in San Jose. And make sure that you hit that subscribe button, follow our podcast, follow our YouTube video, and stay in touch for our future episodes. Okay, thank you again.
Great. Thanks, Roger. Enjoyed being here.